Should past convictions prevent you from getting your pistol permit? Welcome to another installment of the Connecticut Gun Bench. Today's video is brought to you by P.A.N. Firearms, LLC. P.A.N. Firearms for your NRA certification and multifaceted gun training. You can reach us at 203-300-6343 or use our website at www.panfirearmsllc.com. As always, there'll be a link in the description box below. Now, an article from the Connecticut Post crossed my feed, and I found it very interesting. It should be something to be talked about. It was a gentleman from Stratford, Connecticut, who applied for his pistol permit and was denied due to a past conviction in New York. It was a drug conviction. It happened when he was 15 years old. The court has now decided, Connecticut Supreme Court has decided, that this should not be a barrier for him to obtain his pistol permit. And that's why I said, should past convictions prevent you from doing so? In this case, with this gentleman, no. But let's read about him first. From the Connecticut Post, titled, Court, New York Drug Conviction, No Barrier to Stratford Man's Gun Permit. Bridgeport. In a decision that could further open the door to gun ownership in Connecticut, the state Supreme Court has ruled that a Stratford plumbing contractor cannot be barred from getting his gun permit because of a misdemeanor drug conviction he got as a teenager in New York 15 years ago. In a unanimous decision, the state's highest court ruled that while state law bars people with criminal convictions in this state from getting gun permits, the legislature omitted in the law criminal convictions in other states from being a bar to being eligible for permits. So the language here is they cleared this because there's no language in the law that says because you have a conviction in another state, you can't get your permit here in Connecticut. Be prepared for that to change. Our legislature may not have possessed the same certitude with respect to out-of-state non-felony convictions and so decided to leave suitability determinations regarding those crimes to a case-by-case basis, which it should be. Justice Andrew McDonald wrote in the decision for the court, there is significant divergence, after all, in each state's penal laws and accompanying statutory plea bargainings and sentencing schemes. And a conviction for a violation of any one of the 11 enumerated statutes in Connecticut can carry very different implications than a conviction for the same conduct in another jurisdiction. According to court records, in 2006, Anthony Leo was living in New York when he was pulled over there. A police officer subsequently found Leo in possession of 2.5 grams of ketamine, a powerful anesthetic. Leo later pled guilty to a misdemeanor possession of a controlled substance and was given no jail time. In May 2016, Leo applied to the Stratford Police Department for a state pistol permit. The department denied his application in April 2017. Wow. So, because that's, 11 months? Because of Leo's 2006 conviction in New York. They ruled that the New York conviction was equivalent to a Connecticut misdemeanor charge that automatically precluded eligibility for a pistol permit. Leo appealed the denial to the State Board of Firearm Permit Examiners, which in 2018 ordered that he be granted a pistol permit. The Stratford Police Department appealed that ruling, and a Superior Court judge ruled in favor of the police department. Leo's lawyer, C. Christian Young of the Bridgeport law firm Cohen & Wolf, said that the Supreme Court's decision was well-reasoned. The court's decision upholds the integrity of the law, providing for the process of applying for and obtaining a pistol permit in our state, Young said. State Rep. Steve Staffstrom, Democrat Bridgeport, co-chairman of the General Assembly's Judiciary Committee, said in his initial quick browse of the case suggests there is an oversight in the statute. We need to make it clear that the local police chief has the authority to deny the permit based on a conviction under Connecticut law or comparable position of another state's law, said Staffstrom. So that, as I said before, be prepared for that whole ideal of being convicted elsewhere does not exclude you from Connecticut. That's going to change, obviously, and they're going to do it quickly too. But Young said the statutory process for Connecticut firearm permits has worked very well and protected both the individual's rights as well as the society's interest in safety for decades. The Stratford Police Department and the trial court's actions would have disrupted the process and would have expanded the class of people who would be permanently prohibited from possessing firearms beyond the limitations established by the people of this state through their elected representatives, Young said. Young said following his conviction, Leo went on to graduate from college and get married and raise a family while living in Pennsylvania. Young said Leo was able to get a pistol permit there. He said Leo now runs his own plumbing company in Stratford. The town of Stratford is the first town in the state that is seeking to apply equivalency to a misdemeanor statute in another state when it comes to granting pistol permits, said Young. The town of Stratford has chosen to read the statute as being equivalent, even though there is nothing in the statute that states it should be equivalent. Attorney General William Tong wrote an argument supporting the Firearms Board's decision. The board reversed the town's decision to deny Leo a permit on the basis that his conviction in New York is an automatic disqualifier. Leo made a mistake in 2006. Since then, Leo's life has changed. The board found Leo to be credible and reversed the town's decision. The board moves for dismissal of the town's appeal based on the aforementioned reasons, Tong wrote. That is an absolute shock that William Tong, for those of us who've pretty much been in Connecticut throughout this guy's career, that's a shock to hear him even say that. A lawyer representing the Stratford Police Department declined comment on the decision. Now, in this case here, specifically, this case, no. This guy should not have been, prevented from having a pistol permit. Because he was 15 years old, he did something stupid, he has not done anything else since. And that should be the criteria for denial or approval, especially when it comes to conviction of crimes. You had a drunk driving conviction one time 15 years ago, and that shouldn't be a basis for denying you a pistol permit. Now, let me be very clear. If you're a career criminal and you got all kinds of crazy nonsense going on, convictions for this, convictions for that, no, you should not be allowed to have a permit. If you violent felonies, domestic abuse, and you just have a career of it, of course not. Common sense has to prevail. But this is an interesting article, and it needed to be talked about. But I'm glad this guy got his permit, because under this circumstance, something he did when he was 15, no reason to hold him back like that. And I'm not sure what the Stratford Police Department kind of pushed the limit on what that statute actually means to deny this person the permit. But I'm glad he got it, and that's a good deal. Once again, I'm shocked that that Attorney General there, William Tong, actually said what he said. That's kind of surprising. Like I said, if you know anything about him, he's been anti-gun from the word go. So, but there's always a silver lining in everything, I guess. Well, let me know what you think. As always, you can leave your comments in the comment section below. As always, any calls for violence or statements that lead to violence will be removed. Please like, share, and subscribe. Don't forget to hit the notification bell so you get notified the next time a video goes live. And I will see you on the next one. Peace.